Hi guys, welcome back to my YouTube channel. My name is Ahmed and this is Law Talks with Umati. Today I want to explore a concept that affects our daily lives more than we realize, and that is nuisance. And I say this because so many times, and you can see this in your neighborhoods, people construct things that may cause you problems. It's very common, and some of those things could fall under nuisance. We have two types of nuisance under Nigerian law. We have public and we have private nuisance. This conversation concerns private nuisance. Private nuisance refers to an unlawful interference with a person's use and enjoyment of their land or property. That means interfering with their comfort, convenience, health, occupation, etc. Private nuisance falls into three categories. And the first one is physical injury to someone's property. For example, you have a farm and a factory is built near it, emitting gases which damage your plants, or any other activity which affects your property and causes a substantial amount of damage to your property. Number two, interfering with someone's use of their land through noise or smell. For example, in a decided case in 1970, a man sued his neighbor who kept poultry because the chickens made a lot of noise and disturbed his sleep in the morning. And the smells from the poultry bothered him, and he succeeded in his action for private nuisance. Of course, we can't say every noise constitutes nuisance. In order to determine if it's nuisance, we must consider the character of the locality. If that man lived in a rural area where poultry was quite normal, he can't say that his comfort has been interfered with. Land is usually allocated for specific purposes, be it for commercial purposes or residential purposes. Therefore, utilizing land meant for residents to do commercial activities often puts one in a pickle. Many estates have rules or regulations concerning people living there, no fences of a certain height, no this or that. In such areas, violating such rules to the extent where you make someone uncomfortable can be said to be nuisance. This also brings us to the fact that what constitutes nuisance in one locality is different from what constitutes nuisance in another locality. Even excessive noise can be considered nuisance. For example, living in a noisy neighborhood doesn't mean you can't sue for nuisance in a case where additional noise is introduced. You can sue provided the noise is more than you usually have to live with, and if that noise is substantial. The third category is obstruction of right of way or light. Rights to light refer to rights to receive sufficient light through an opening such as a window, allowing ordinary comfortable use. A person can interfere with your right to light using trees or buildings which obstruct your access to light. Some other things we need to consider when it comes to private nuisance is reasonableness, which is concerned with doing right by everyone. In as much as you are allowed to enjoy yourself, you mustn't make another person's life uncomfortable. However, an unusually sensitive person may not likely succeed in a claim for nuisance, and this is because the court applies tolerance of a normal person. This means that the court will look at what will make a normal person uncomfortable and not an unusually sensitive person to determine if an act constitutes nuisance. But where the person carrying out the act is aware that the other person is unusually sensitive and still goes ahead to terrorize him, the law will not protect that person carrying out the act. Duration of an act can help in an action for nuisance, for example, where the action continues without a specific term limit. Additionally, where there is malice, it can give the impression that an act is unreasonable when someone is trying to annoy you. Where a person's action is considered to be malicious or done to annoy a neighbor, the court will give judgment to the plaintiff as it will be considered nuisance. Therefore, the elements you need to establish a claim in private nuisance are: the first one is substantial interference. The interference must be significant enough to affect the claimant's enjoyment of their property. And the interference must be unreasonable, highly unreasonable. And when it comes to this, you have to look at factors such as locality and nature of the area. and directness, which we've already discussed, that there must be a direct link between the defendant's action and the interference caused to the claimant. The duration is also important. The interference must be continuous or recurrent over time. However, there are certain defenses that a person might raise against a private nuisance claim, such as contributory nuisance. If the claimant's own actions contribute to the interference, the defendant may argue that the claimant is also responsible for the situation. You can use the defense of statutory authority. A defendant might be able to justify their actions by showing that they have a legal authority or permission to carry out the activity causing the interference. The third defense is reasonableness of the act or omission. Fourth one is act of God, act of a stranger, or sometimes even consent of the person complaining. When someone successfully proves a private nuisance claim, they may be entitled to remedies such as injunction, that's a court order that prohibits the defendant from continuing the interfering activity, or damages, and that means financial compensation to make up for the harm caused by the interference. And that wraps up our discussion on the tort of private nuisance under Nigerian law. Remember, each case is unique and the outcome can vary based on the specific facts and circumstances. If you found this video informative, give us a thumbs up and consider subscribing for more legal insights. Thank you for watching, and we'll catch you next time.